Okay, welcome everybody. Um, in the interest of time, I'm going to ask if folks want to do a quick introduction in the chat space. If you just want to tell us who you are, where you're dialing in from this morning, um, anything else you'd like to share. Maybe how's the weather where you are? It's starting to get cold where I am. We're moving into autumn, which I greatly prefer because I'm not a summer person. Uh, we have with us here this morning fellow facilitator Paul West, dialing in with us from South Africa. Welcome. And our special guest today is Meredith Jacob, who is the director of the Project on Copyright and Open Licensing and the director of the Program on Information Justice and Intellectual Property at American University Washington College of Law. She's a co-author of the Best Practices in Fair Use for Open Educational Resources, which you might hear about in a little bit. And Meredith is going to do some introductory remarks. And then we'll have lots of time today for questions and answers. So what we usually do is I like to preference questions that are from people here in the room with us today. So we do have a questions document where you were able to post questions in advance. If you did post a question there and you're here, let us know and we'll skip to yours. If you did not post a question in that document, that's okay. Ask us your question anyway, or if you have some relevant thoughts or experiences to share, please do that. The more interactive this is, the nicer it is for everyone. And then if we run out of questions from folks who are here in the room, we'll go back to our questions document and start working our way through that. So with all of that, I'm going to turn things over to Meredith.
Thanks, Shanna, and thank you all for making it here, whether it's early or late in your own day. For some of you, I think we see folks on both ends of the spectrum, so thank you. So my name is Meredith Jacob. I'm a lawyer and I work at American University's Washington College of Law, and I do a lot of talking to folks out there in the world about how the Creative Commons licenses work and how they work within the environment of copyright law. And in that work, I do something that I think it is important for all of you to get comfortable doing, which is giving people meaningful legal information and technical assistance without giving them legal advice. And that's something that's often hard for the folks who are here in the certificate, because you come here because you maybe already are a sort of local expert about copyright or open licensing in your institution or your community, or because you want to help people solve problems with copyright or licensing that they have. And those are really good and valuable things. And at the same time, for almost all of us, for a collection of different reasons, it's pretty important to not give other people legal advice. That's important for me because even though I am a lawyer, I'm not your lawyer. I don't have that business relationship. And it's important for many of you for that reason. You're not someone's lawyer, but also because you're not a lawyer. Um, and those are both important things to keep in mind. That being said, it'd be sort of useless if we all went out there and were like, well, yep, that's your problem. Can't tell you, can't help you, not your lawyer. Right? Like, that is not how any of our professional work happens. And so we need to figure out how to sort of navigate that line. And there's a couple of things that have always been very useful to me to keep in mind there, and that I hope will be useful to you. The first is that information about what you think the rules or the law or the policy, what you think those things are, that's legal information. That's not advice, right? Advice is taking those rules, applying them to someone's very specific fact-based problem, and then saying, this is what you should or should not do. The other thing that I've always found very helpful is examples and hypotheticals. I think those are often, in many cases, more helpful than a very long sort of description of what I think the law is or what I think I've read in, descriptive work, but to say, here are some examples of stuff that people are really very comfortable doing and that seem to be working well for them. That also brings into context that in most cases, practice is really going to be a mix of what people think the law is and what works for them professionally. The other thing to remember is that telling people no, that they shouldn't do something, that is also giving them legal advice. And I think often sort of well-intentioned folks, particularly in education and research and librarianship, often can sort of default to telling people no as a way to avoid sort of perceived risk of giving legal advice. But telling someone, no, you shouldn't do that, that is also sort of meaningfully giving them advice. And it has this sort of chilling effect where people say, well, I'm not your lawyer. I can't give you advice. So you shouldn't do that. But for most of us professionally, choosing not to do something might minimize perceived copyright risk, but might pose a pretty big risk to your mission, right? To your mission of education or research, to your mission of providing access to the public. So I think it's important that if you're not going to give someone advice, don't give them advice not to do something as a sort of default. So that's my big picture about thinking about whether or not you're giving someone legal advice. A lot of folks here probably do give colleagues advice of different types and try to give projects advice about how to go forward. Does anyone here have any questions about cases where they are sort of on the fence about whether or not they should give somebody advice in a situation? Anybody? These Q&As are more interesting if folks unmute. So I'll prompt you from time to time, but I know lots of people aren't in a place where they can. So if you have a thought in the chat, please drop it in there as well. Whether there's a situation where you feel like you're sort of on the border of is this giving legal advice or not?
I have I guess a question or an example. I'm not sure.
Yeah, thank you.
Um, I had a faculty member. I work at a university, and I had a faculty member ask which Creative Commons license should they choose. Is that, and this may seem basic, but it's just a question that I have. If I give them, I never gave them a definite answer. I just kind of explained each one to them the best I could at the time, but I never gave them an answer. But if I were to say, oh, this one is probably the best, is that giving them legal advice, doing that?
That's an interesting question. I think that's sort of, I think that's probably answering that question is probably sort of below. If they just say, which one do you think I should choose? That feels pretty minimally legal advice to me, right? If they go, which one will do this thing, like which one will accomplish this goal, that gets a little bit more there because you're saying, like, what is the function of this license, right? But I think probably you did what is the best thing there, which is to say, well, different licenses have different effects, right? Like, if you choose this one, this is what the result will be if you choose this other one. Like, at some level, that faculty member might be best suited to deciding what they want out of their material, right? Like, you can help them understand what the different licenses do, but the question of what they should pick really has to come back to them at some level, right? Um, the other thing that I would often do in that situation is say, well, you know, if a faculty member was thinking about an OER, for example, an open educational resource, the best thing there might be to sort of say, well, I often recommend that folks choose CC BY licenses because those have the least restrictions, and sometimes restrictions complicate other people using your stuff. So if you want the most people to be able to use it, I'd pick a CC BY license. There are other restrictions, you could add in this non-commercial term or this share alike term, but sometimes non-commercial terms can cause questions or confusion when people are having materials printed or using them in tuition-bearing classes. So, and I think you could say, I might pick this one, like I think that's really a choice. It doesn't, to me, I don't think that rises quite to the giving legal advice. But even there, I think a good answer is, laying it out for them. And you can say, like, I think this one has a lot of benefits, but let them make the choice themselves.
Thank you.
Yeah.
I feel so much better now because that's how I typically approach those questions. So I feel validated. Thank you, Meredith.
have to hide the, like, you know, in these situations, it's not your job to be like totally neutral. Like, I often tell people, I think you should pick CC BY licenses because I think the restrictions do more harm than good. I think that they confuse folks, but they don't meaningfully limit what bad actors do. But, you know, they're out there and you should make your choice. And so, like, I don't think, you know, I think you cross over a line if you you definitely should only pick this one. But you also don't have to pretend that you don't have it. You don't feel like super neutral, you know? Um, so Shanna has another example in the chat, which is a question about copying one chapter from this textbook and giving it to all their students. They don't have to buy it. Is that okay? And there's a document I was going to ask Shanna to add in the chat, which is a best practices and fair use for research libraries that was published with the Association of Research Libraries. It's separate than the best practices and fair use for OER. It's a little bit older, but it talks a lot about course reserves. And so if I got this question, I would I would link somebody to the best practices and fair use for research libraries and say, yeah, you know, in a lot of different situations, instructors want to use chapters. There are times that can be fair use. It depends a little bit on what the chapter was originally written for, like what purpose it was here, and then what purpose you're using it for in your class. But here's this best practices that can help you think through that situation. And then, you know, I think the other information you can give is often professors do that for one chapter of a book on a different subject, but it's not, you know, usually a good practice to do it if you're substituting directly for a textbook in that subject. So you need to leave the decision at some level onto them, because there are plenty of times where copying a chapter and giving it to students might be fair use, and there are times when it's not. And so that's a situation where I think many libraries, out of risk avoidance, default to giving no legal advice, giving negative do not do it legal advice instead of actually sort of staying neutral. I'm going to jump into the questions in the legal webinars document. And so if folks have ones there that they're here and they'd like to discuss, please put them in the chat. Otherwise, I'll go through them in order. So a question here is, when digitizing cultural heritage materials, is there a meaningful legal distinction between reproductions of 2D works, e.g. paintings, and those of 3D works, such as sculptures? How do courts typically assess originality in these cases, and when might new copyright arise? So there's sort of two questions that might be bound up in there. And one is, if you are a cultural heritage organization, what should you do ethically and legally? And then there is if you are someone out in the public, how should you treat those images? And so starting with the first one, if you are the cultural heritage organization, I would strongly encourage you from a policy standpoint to make those images CC0 or CC BY. You know, in the United States, the sort of working legal assumption is that 2D reproductions of 2D art, so a faithful digital reproduction of a flat piece of visual art, where the visual art itself is in the public domain, that photographic reproduction of it does not have a new separate copyright. I think in questions that are photographs of sculpture, I think we generally work under the assumption that those have separate copyright. And as far as I know, I don't know of any cases that are about 3D faithful scans of 3D sculptures, but I think the legal principle would be that if you have done nothing artistic in the framing, if you are just documenting thing that is aged into the public domain, that there isn't sort of new originality in that. So in those situations, it doesn't keep people who digitize them from sometimes claiming copyright or another ownership or sort of access right. I think that's disappointing when it happens, because it's sort of claiming that, just because you have custodianship of the object, you somehow have some legal interest in the information about it. So I would say that I would hope that institutions would license the reproductions of those that are sort of just faithful documentation, both 2D and 3D, as CC0, as to not assert additional ownership interest in it. And I think for both the 2 and 3-dimensional documentation in the US, I would operate under the assumption that those did not have new copyright. Pictures of sculpture often do, like flat 2D pictures, because they do have a new sort of artistic perspective on how you frame and capture the sculpture. But there's just not that much. Most of the case law is about 2D representation of 2D images. That's a sort of very technical discussion of that. So I don't know who asked that, but if you're on, maybe we could talk a little bit about whether that answers your question. Does it answer everyone else's question about that? I feel like I said 2D and 3D a lot. Did that make sense to folks? Did anyone lose the thread? Seeing some thumbs up, that's good. So the next question is, are there instances where works are licensed under earlier versions of Creative Commons licenses are updated to 4.0? If so, how does it work, and is it necessary or optional? So it's not necessary. And the answer to this question also sort of answers question 8, which is, can we revoke the CC licenses or change them? So the CC licenses are designed to be irrevocable. So they're designed to not be able to be sort of taken back. And I think that's because fundamentally there's the belief that other people, very explicitly in the licenses, are going to build upon those, right? And so if you revoked your license later, it would mean that the thing that I had built on that, I didn't have the legal right to use anymore. So the licenses are designed to be irrevocable. What they aren't is exclusive. So if you originally licensed something under a CC BY 2.0 license and you want to update it, you can easily do that by re-releasing it with that 4.0 license. The 2.0 one will still exist, but the 4.0 one will exist in parallel with it. And so people can operate under the terms of the either license. So as long as they complied with the terms of either license, they'd be complying with the license terms. That is true sort of in inverse in the answer to question 8, which is, can we take something and make it CC, from CC0 to CC BY in CSA 2 years later? And the answer there is one legal and one practical. So legally, once you have put something out under a more permissive license, so CC0, for example, a public domain dedication, you can't meaningfully take that back. So that is always going to be out there. If you later regret it, you could stop hosting it yourself and host it under the new, more restrictive CC BY SA 4.0 license terms, and sort of hope that people didn't know it. And that would be pragmatically probably useful in some situations, but it wouldn't actually change it. The other direction of saying, I had a more restrictive license and now I want a new, more permissive one, works fine. The more restrictive license sits there, but the more permissive one gives people the permission under that license. This is also true in that people can write commercial licenses that sit and operate alongside the CC license. So if I have all my work out under a CC BY license, but someone wants to incorporate it and doesn't want to attribute, and they don't want to have to like understand or rely on the licenses, I could write them a commercial license where they pay me to use it. And that could operate just fine in parallel with the CC license. Does anyone have any questions about the sort of multiple licensing issues? I see a question around the no derivatives condition and how much changes are required to be a derivative instead of a new work entirely. I'm not sure I totally understand that question. Would you be willing to unmute it and talk to me on that a little bit?
Sure. Hi. Thank you. Oh, my camera. Thank you so much, Meredith, for joining us today. I really appreciate it. I work at the University of Michigan and I support a lot of researchers using CC licenses. And sometimes they are using other work that's released with the no derivatives condition. And sometimes they're concerned about their own work themselves. I just was wondering when they're making adaptations of work and things are changing over time, is there any like criteria or things that we could say like you have to change 90% or you have to change this and this and this, and then it's not considered a derivative and it's considered a full new work? Or if it's always based on something else, there's always that small portion that would be a derivative, if that makes sense. Like kind of
Yeah.
like
So
trees and changes.
there's a piece of this that I can answer for you, and there's like two different pieces. So one complicating factor is that the definition of derivative work for a Creative Commons license doesn't exactly line up with the definition of what a derivative work is in US copyright law. I think perhaps the simplest place to start is that in many of these cases, you may not need to reach the license. Can you give me a more like concrete hypothetical?
Um, I have a researcher who's made a program um that sh this one is not as much as CC, but the derivative aspect applies. She made a program at another school, so the program was owned by the other school.
A
She's
piece of
moved over.
software.
Yeah.
Okay.
Well, this one is a like more like a manual, like a booklet, like content in a way,
Okay.
not software. But she made a program, and then she left that school. She moved over to our school, and then she's continuing to adapt the program. And so she's making derivatives, but at what point is it not a derivative then, and it's just net new material that would be at our school instead of the old school? Or like, when does
I,
something get diluted enough that the original's not there anymore?
so uh this is an interesting question because I think it's something that's always been a part of creative work and is a part that um is really sort of brought into close scrutiny uh in this sort of AI question, which is like, there's the like Picasso quote that art is theft, that like everything you build at some level is built on another thing. And so the question is like, how do we think about and delineate those lines? And in the US, for those of you thinking about there, the core question is going to be about questions about fair use and questions in all copyright jurisdictions, questions about the idea expression jurisdiction. Distinction. So copyright lets you own the fixed like expression of something. You own the words to some extent, maybe you own the paragraph structure. Is You own that, but you don't own the ideas. So the extent that she had this program and she taught you that like the 6 steps that you need to do to evaluate a patient, and so pretend she's teaching nursing, just as a hypothetical. And she's like, all right, the 6 steps you need to do when you evaluate a patient are step 1, X, step 2, Y, like that, right? That is not something that is ownable under copyright law, right? Like that's an idea of how you treat a patient. And so she'd written a pamphlet there about that, or like a workbook. And then she came to this new school and she wrote a workbook there. There'd be a question of whether she was sort of just writing out the exact sort of same steps in the same language, but to the extent that it was really writing about the idea, and there's only sort of a limited way to write about that, the general similarity between the two isn't enough for there to be copyright infringement. So we don't let you own ideas. And then there are these two copyright doctrines. There's idea expression distinction, right? Which says you can own the expression, but you can't own the ideas, even if the ideas are what are really valuable. And then the second is one that's more boring called merger. And merger basically says if there's only a couple reasonable ways or like functional ways to express something, you don't get to own that just because you wrote some copyrighted version of that idea. We see the second idea in some of the cases came out of computer menus. So like Microsoft can't own that the choices that you want in a computer menu are save, edit, open, whatever. That like even though they had arranged that's just those are just the things you do. And copyright doesn't let us own that. So one thing here is that just because something is built on something else doesn't mean it's meaningfully a derivative from a copyright standpoint, right? What you're really thinking about derivative work is like, can you go through and trace out, like with a highlighter, meaningfully long, sort of coherent areas of identical text? And with the sort of background thing that some text is going to be identical or very similar when you are discussing similar things, because that is the clear, effective way to say that. And that's going to be more true when the type of thing that you are looking at is functional, and less true when the type of thing you are looking at is artistic, right? So like how you think about that for like a first aid manual of how to deal with cuts and scrapes, and how you think about that for a novel about a week at the beach, it'd be really different, right? Like if you have 10 sentences that look really similar in a novel, you're like, oh, like you had, 10,000 words to pick and you put these together this way. And at the same time, in a first aid context, you probably open every first aid book and find a sentence that's like, first assess the scene for safety. Like, I'm willing to bet you that sentence is in a third of them. And in that situation, it doesn't make any of them derivative works of each other. It's just like, that's the first step. And so that's going to be part of that question there. Have I answered your question at all, or just veered off in a wildly different direction?
Half and half, but I'm appreciative of the insight either way. I know
Um,
that this week we're doing no derivatives as part of the course, so I feel like I'll gain more info on it. It's just I've always struck like the commercial one makes total sense to me. The no derivatives one, I think I just have so many flavors of different scenarios that I encounter
so
that
part of it is, and I'm going to say this, even though we're being recorded, the no derivatives license is sort of a dumb license. That's a technical term. If you go to law school, to be like, I don't know, the license is sort of dumb. The no derivatives license really came into play, I think, in the origins of the license drafting, because people wanted to put artistic things, creative works, out there in the world for people to use and enjoy and distribute, but wanted some creative ownership and sort of artistic integrity to that. So people were thinking about the no derivatives license for like music and film and like visual art, where they were like, if I put out my song and it's like a sort of melancholy slow song, I don't want you to make like the Miami mix of that song. Like my song is sad. I don't want it to be like don't do it. And then unfortunately, I think people have sort of gotten into the no derivatives license to do like pedagogical work and to be like, I don't want people to get to change my opinion about this. And that I think is why, broadly speaking, that second reason is sort of dysfunctional, and it's why folks in the open education community mostly don't consider things that are no derivatives licenses to be open education. And I would probably gently counsel people to not choose no derivatives licenses outside of a really narrow sort of artistic perspective, or one in which there was a sort of very personhood reason for not having changes. The other thing I think in the case of lots of non-derivative licensed work is a question of whether if you have a fair use argument for using something. So like if I'm doing if I'm making a parody of something, and so if someone made like a piece of corporate sort of PR, they put a no derivatives license on it, and I wanted to make like a anti-corporatist parody of it, I can do that under fair use. So it doesn't matter that the license says no derivatives. I get to ignore the license because I have a legal right to do it. So I don't need the license.
Thank you. That's helpful.
That is my whole non-derivatives journey. But I hope it is useful. Now we will attempt to get this chat back on the rails and answer some real questions. Can I include materials with all rights reserved in a CC license work under the fair use doctrine? Yes, absolutely. When does such a reuse qualify as fair use? Funny you should ask. I spent a year writing a best practices in fair use for OER to answer exactly that question. And happy to talk about it at length. I could talk about it for the remaining 27 minutes, and I won't, but I'll give you a few quick highlights. One is that, creating high quality OER or creating sort of material of all types is not a closed book test. And so when you use an open license and you're going to include all rights reserved material, you need to make sure that you have the ability to do so under fair use or fair dealing if you're in the UK or Canada, or under a specific exception for research or education or study in other countries. All countries have exceptions to copyright, and all countries have, for example, the quotation exception. And so this is not sort of an American exceptionalist view. And in fact, in the best practices in the appendices, we talk about the quotation right and we talk about fair dealing and how these are in large part extendable to those jurisdictions. But as you're doing it, the first question always needs to be, I have the material I'm creating. When I look at this outside copyrighted thing that I want to bring in, why do I want to do that? And you will be best suited if you answer that question really specifically, like how you would answer that question if you were explaining it to another expert in your field. Like, I want to include this quote because it shows the political opinion in 1955 about X. And that's important context for my students to understand these later two things. Once you have that, the question is it a different purpose than what the material was originally created for? That's the fair use question. And then the answer is, am I using the amount I need to? And what you'll find is in very, very many situations, if it is the correct pedagogy to include this other thing, and it came from something other than a sort of similar textbook or teaching material, that there's a high likelihood that it's fair use. You need to go through that analysis. But what we find is taking existing sort of historical, cultural, journalistic things, excerpting just the amount you need, and embedding it in your OER for that specific pedagogical purpose is very often fair use. The thing that is less likely to be fair use that I think folks sometimes ask about is taking an excerpt from a very similar commercial teaching material, a textbook or a worksheet, and including that. That is the area in which fair use is likely to be the least helpful. Happy to talk through fair use questions ad nauseum, but I'm going to try to get through a few others, and if we have some time at the end, we can answer some specific ones. Though if someone on here had one thorny one they've been grappling with, I can talk about it as well. The only other thing I'll say is it's very important when you include fair use materials in your OER to make that clear. And there is no one sort of magic way you need to mark that. There isn't a formal sort of citation like there is for the CC licenses, but you just need to make it reasonably clear to a reader that they know what is included under the Creative Commons license and what is not. So question 4 is, when a work of art is displayed in public, should others be free to photograph it and reuse it for their own projects, or should the original author's copyright still restrict that use? So the first question is, does the original author still have copyright? And so that's just a question of term, right? So for lots of old art, there is no copyright anymore in the original work, but for work created in the modern era, there is. And so then the answer is that artist copyright still exists. And the question is, what uses does it restrict? And so this is, again, sort of the inverse of that question early on about taking photographs of public domain art and sculpture for cultural heritage preservation, whether there's a separate copyright. So if you are taking a picture of a still in copyright piece of visual art, if you are taking a faithful reproduction of just that picture, that's very likely, if you sell it or disseminate it, to potentially be copyright infringement. There are certainly exceptions in which that is fair use. If you take a picture of it and you discuss it in an article analyzing changes in painting style over time, there's a really strong argument that's fair use in that context. If you take a picture of it and you sell shower curtains, it's not, right? That comes down to the purpose. Why are you taking the picture and what are you doing with it? There's also separate doctrine in many countries about taking sort of larger angle pictures of a whole scene and saying that to the extent visual art is included in that there isn't an infringement claim. Does that answer that question, or does someone have follow on there? There's a couple questions about the non-commercial licenses. There's confusion about it because people want their work to be shared openly but not used for profit. However, there are commercial uses that don't generate profit. Can I clarify what counts as a commercial use, particularly within a university setting? The answer is only sort of. And that is unfortunately because I think a lot of users choose the non-commercial term to sort of mean no bad actors. But unfortunately, the no bad actors license is very individual specific, right? And so the non-commercial license means you can't, I think the text says you can't use it primarily for commercial advantage. And there's the guidance link there's some there, but a lot of that's old. It's from like 2008. I think the honest answer is that these are very community specific questions. And so the way that a non-commercial license might be interpreted in like the US higher education community is really different than the way it is understood in like the German Wikimedia community. I think in the US, for example, people have pretty much come to terms with the idea that non-commercial licenses do not restrict printing educational materials at cost recovery. They also don't restrict using them in classes at, a not-for-profit institution of higher education. I think, broadly speaking, people don't, in the US, interpret tuition-bearing not-for-profit courses, whether it's a textbook or a whole course, as being in violation of the licenses. But I don't know that that's true everywhere. I personally wouldn't hesitate to do it, but I think it's a reason I again encourage folks to choose CC BY licenses for their work, because I think it creates the lowest friction for well-intentioned reusers who are following the licenses. Any other follow-up questions? Just I'm going to read a couple in the document and sort of organize an answer.
Meredith, we do have a question about fair use in the chat, but I understand if you want to wait till later for that one, up to you.
I can answer it.
It's from Jessica Richmond. We have an instructor who wrote a textbook and he'd like to make it available to his students, but the publisher owns the copyright. So
Yeah.
is there a way to apply fair use in this situation? There might be other things to consider.
Yeah, so generally, if the questions here would be like, is the textbook sort of still out there in the commercial stream of things, if the textbook is still out there being sold and the publisher owns the copyright, fair use doesn't really allow him to just sort of take the whole textbook and make copies of it. If the textbook is not being out there and used, there's some work around copyright rights revision, which is ways for authors to get their copyright back in situations like that, which I would look into. And then the other important thing is that even though they own that specific textbook, unless there is something additional in his publishing contract or his or her publishing contract, you could write a new textbook, you know, same ideas, but different sentences, different, sort of paragraph structure. And they don't own that, right? They don't own his knowledge about biology or economics. But just using the textbook absent any of those sort of special situations is not going to be fair use generally. It's just because the whole question is, what was the original purpose? And it was to be a textbook for that class. And then as long as you're using it for that same exact purpose, there's not that sort of transformation that is the key part of fair use. Copyright for published works of companies just is treated like copyright for the same as individuals. It has a term of 95 years from publication, because there isn't that sort of life for the calculation of copyright term. The only thing that might be implied in 6, did the person who asked 6, are they here? Are they in the chat? How does copyright function regarding published works of companies, especially those with no named author? The other thing I would just say is that question makes me think of questions around orphan works. So orphan works are works for which no copyright owner can be found. And for works published by companies, a lot of times those are sort of more instrumental. And there's best practices and fair use for digitization of orphan works that talks a lot about that and about how you can use fair use to make those works available. I'll put that in the chat. Oh, no, I did not put it in the chat, just kidding. Okay, so I have one more question in the chat, and then we can answer some. There's one more question in the document, and we answer some from the chat. So we answered the CC license textbook ones. Question number 9, which is how do CC licenses interact with other licensing or publishing agreements that authors sign when publishing academic research? There's a specific one here. I'm just gonna read that real quick. So there's a question in the chat. Did you understand correctly that orphan works can be used under fair use? And the answer is yes, they often can be. That's what that best practices and fair use talks about. We don't have dedicated orphan works legislation in the United States. And there's a very long, well-written law review article by a woman named Jennifer Urban, who's a professor at Stanford, talking about this, but which basically says that to the extent that market harm, so we don't talk about the market harm factor very much in the sort of modern fair use doctrine. We talk a lot about transformative works, but there is this market harm factor in the US 4-factor fair use analysis that says one of the questions you look at is how does your new use harm the market for the old thing? And Jennifer's argument, and something that's discussed in those best practices, is that if there is literally no one to reach to ask permission or to pay for a thing, it makes that market harm factor really strong, like really sort of zeroed out, right? Which makes it really strong in the analysis, which is if one of the 4 factors of fair use is, was there some market harm? If this thing is entirely out of the market, it makes it really hard for you to find that there was any market harm. And so, yes, and this is particularly true in the case for all sorts of orphan works that were created for some sort of ephemeral or institutional or instrumental purpose. So, instruction manuals, playbills, newspaper articles, posters, all of these things for which they had some sort of original sort of instrumental purpose, but you know, the author and the owner are sort of long gone. As you know, Shannon notes, in those situations, the actual risk is also very low. But Suzanne, if you had a specific question, I'd be happy to answer that. But using it includes making derivative works, and so that fair use certainly allows you to make things that would otherwise be called derivatives. Suzanne, do you have an example you're thinking about?
No, just mostly orphan works always felt like this gray area that we lost them. It's unfortunate they're gone. And I love that there is a way we can in fact use them. So no, I was just mostly happy to hear that.
Yeah, so it includes, I mean, like the fair use can allow you to do sort of all the things under copyright. The best practices talk about that, but I would actually say that, you know, fair use is really strong when it comes to orphan works. So if you have, yeah, so I think in fact the power of fair use in the arena of orphan works is very large, and the best practices in fair use for memory institutions that talks about the digitization of orphan works does so explicitly under the idea that you're not digitizing them to like bury them in a box in the ground, that you are digitizing them to share them with the community and to enable people to use them.
Can I ask one more follow-up question? I'm so sorry.
Yes, absolutely. I'm just trying to mute my Teams because other people are getting into the office and sending me messages very inconveniently.
Okay.
Please go ahead.
So, but it would probably not be wise to use it as like I would use another OER as the basis for some derivative textbook or whatever that I'm creating and hope to add a license to.
Yeah, you know, that's an interesting question. So, there's a section in there's the 4th section in the best practices in fair use for OER, which talks about repurposing pedagogical materials in the creation of OER. And one of the things we think about and talk about there explicitly is using basically sort of orphan works materials as a repurposed thing in the creation of OER. There's some interesting, like, there are questions that you have to sort of sit down and think through more carefully, but I think the answer is sometimes yes. It's an interesting category of stuff, and so I'd be happy to sit down and think through like some of those problems with you. Like we're always trying to build out new cases for that. Do you have a situation you're thinking about a little bit more specifically?
No, actually, I don't. This was very hypothetical. But if I find one, I'll reach out.
Well, so I'll put my, to everyone, I'm putting my email in the chat. And you know, what I said earlier, which is I think examples really help people understand what they can do. So when people come up with new sort of interesting example cases, we're also always happy to sort of work through and create a hypothetical that can document that so that folks can, so that it can be an example to other people at how they might go forward. Okay. So we are sort of coming to the end of time. We have about, I have to go maybe in 5 minutes. So I just want to see if we have any last questions, anything that's burning a hole in somebody's pocket. Otherwise, I think we'll wrap up. Thank you so much for coming. And thanks for the time you're taking in the course. And hopefully I will see you out there in the real world or the internet sometime again soon.
Awesome. Thank you so much, Meredith, for taking the time out of your day to join us this morning and to sit in the hot seat and answer questions. Thanks everybody else for your wonderful questions. And if you think of more as you're working through Unit 4, keep adding them to that questions document, because we'll have another round of question time next week with CC's Copyright and Licensing Council, Kat Walsh. So thank you all. Enjoy the rest of your week. Thank you to the facilitators who were on the call helping out today, and we'll see you all around.